Criminal law, as distinguished from civil law, is a system of law concerning with crimes and punishment of individuals who commit crimes. Thus, where in the civil case, two parties dispute their rights, a criminal prosecution involves the government deciding whether to punish an individual for neither an act or an omission. A crime is any act or omission in violation of a law prohibiting said action or omission.
Good morning, guys, and I will discuss the characteristics of criminal law. First one is general or generality. Criminal law is binding on all persons who live or sojourn in Philippines regardless of age, sex, or nationality. Second one is territorial, or known as territoriality. Criminal laws are only applicable only if the crime is committed within the Philippine territory. And the third one is the prospective or prospectivity. Criminal law cannot make an act punishable in a manner in which it was not punishable when committed. See Article 366, the law looks forward and not backward. But of course, there are exemptions. And what are the exemptions under generality characteristics? Number one is as provided by the treaty stipulations like RPUS VFA agreements or the visiting forces agreements between U.S. and the Philippines. First and foremost, the U.S. exercises an exclusive jurisdiction over U.S. personnel with regard to offenses relating to security of the U.S. punishable under the law of U.S. but not under the law of the Republic of the Philippines. For example, kapag ang isang Amerikano ay pinatay ang kapwa niya Amerikano, hindi may a-apply roon ng criminal law ng Pilipinas. Another example, U.S. shall have the right to exercise within the Philippines all criminal and disciplinary jurisdiction conferred on them by the military law of the U.S. over U.S. personnel in the Philippines. It means we have no jurisdiction over their military law. And the second one under generality is as provided by the law of preferential applications under RA 75 grants protection to diplomatic representative, ambassador or other public ministers or foreign countries, including their domestic servants authorized and received by the President. Any crimes that is punishable for 6 years below or crimes punishable by prison correctional that has been committed by these persons, such as the diplomats, ambassadors of the public ministers of foreign countries, including their domestic servants, are exempted to be punished. At kung mahuli man sila, ay hindi sila pwedeng makulong at i-dismiss lang ang kanilang kaso. Pero paano kung punishable more than 6 years ang nakomit nilang kaso, lalo na kung tungkol sa drugs? Makukulong sila pero hindi na sa bansa natin. I-deport sila sa bansa kung saan sila nanggaling o ibabalik lang sila sa kanilang country of origin. And the third exemptions under generality characteristics are the person who are exempt because of certain principles of international laws, sovereign and other head of states, ambassadors, ministers, ministers' residents, and other charges d'affaires. Presidents, ambassadors, and other country heads of the stater are exempted from the jurisdiction of the Philippines, and all of these exemptions are in generality. So let's move on to the exemptions under territorial characteristics. And the exemptions under the territorial characteristics is number one, when the offender shall commit an offense inside the Philippine ship or airship. Number two is when the offender should forge or counterfeit any coin or currency note of the Philippines or obligations and securities issued by the Philippine government. Number three is when the offender should be liable for the acts connected with the introduction of the Philippines of the obligations and securities mentioned in number two. The territoriality principles means that when they are far from the Philippines territory, bawal na silang hulihin. And number four, when the offender who is a public officer or employee abroad shall commit an offense in the exercise of his function. For example, ang isang Pilipino ay may kaso ng graft and corruption at nag-ibang bansa. Pwede natin silang pabalikin sa Pilipinas. Number 5 is when the offender should commit an offense against the national securities and the laws of nations. This explains the terrorist, bawal na bawal ang maging terorista. Kaya kahit saan ka man na bansang pumunta, pwedeng-pwede ka nilang hulihin. Down to the last characteristic is the prospective characteristic. It is the law as a general rule. The penal laws cannot make an act punishable in a manner in which it was not punishable when committed, except when the new law is favorable for the accused. For example, ang estafa dati ay punishable ng regional trial court, pero nung binabaan ng penalty at ginawa na lang 6 years and below, ang mga accused sa estafa before the enactment of this law ay nag-benefit sa batas na ito. Kahit mataas ang penalty ng estafa noon, bababa ang penalty nila dahil sa bagong batas, except if these criminals are considered as habitual criminal. So, who do we consider habitual criminals? These are the accused who are deemed an habitual criminal if he had been convicted and sentenced at least 3 times by the courts of this country for any of the crimes of robbery, larceny, estafa, embezzlement, or forgery, or a violation of laws against vagrancy or prostitutions, or these 3 of said crimes, and that his 3rd conviction and sentence must be within the 10 years following his liberty or last conviction, which must be the 2nd. So that will be all for the criminal law or the characteristics of criminal law. Let's now proceed to the next reporter.
Mabuhay! And now, we are talking about the sources of criminal law, which are the Revised Penal Code and Special Penal Laws. First, Revised Penal Code Act No. 3815, otherwise known as the Revised Penal Code, is the basic law that defines criminal offenses and provides penalty for the commission of those offenses. The Revised Penal Code took effect on January 1, 1932, or more than a year after its approval on December 8, 1930. The Revised Penal Code is divided into 2 books. The first contains general provisions regarding criminal offenses, the persons liable, and the imposition of penalties. On the other hand, the second book describes the act that constitute criminal offenses and penalties for the commission thereof. The Revised Penal Code replaced by the Old Penal Code, which was based on the Spanish Penal Code of 1870. A Spanish royal order in 1886 extended to the application of the Spanish Penal Code with some modification to the Philippines. Apart from the crime penalized in Revised Penal Code, several other pieces of criminal legislation have been passed, penalizing acts such as illegal possession and trafficking of dangerous drugs, money laundering, and illegal possession of firearms. These are called special penal laws, and they form part of the Philippine criminal law. There are certain differences between crimes punished under the Revised Penal Code and Special Penal Laws. Furthermore, violation of the crimes listed in Revised Penal Code are referred to as mala in se, which literally means that the act is inherently evil, bad, or wrongful in itself. On the other hand, violation of the special penal laws are generally referred to as malum prohibitum, or an act that is wrong because it is prohibited. Thus, no criminal intent is needed in order to find a person liable for crimes punished under special penal laws. As long as the act is committed, then it is punishable as a crime under law. Note that, however, Not all violations of special penal laws are mala prohibita, while intentional felonies are always mala in se. It does not follow that prohibit acts done in violation of special laws are always mala prohibita. There are some distinction between crimes punishable under revised penal code and special penal laws. One of them is that crimes punished under revised penal code is that moral trait of the offender is considered. That is why liability would only arise when there is criminal intent or negligence in commission of the punishable act. In crimes punished under special penal laws, the moral trait of the defender, or rather offender, is not considered. It is enough that the prohibited act was voluntarily done.
For the basic maxims in criminal law, first is the doctrine of pro reo. The doctrine of pro reo provides that whenever penal law is to be construed or applied, and the law admits of two interpretations, one lenient to the offender and one strict to the offender. That interpretation which is lenient or favorable to the offender and will be adopted. Second is the nullum crimen nullia poena sine lege. Nullum crimen sine lege is sometimes called the legality principle. It is also interchangeable with nullum poena sine lege, which is translates to no punishment without law. And lastly is the actus non facit reum nisi mens sit rea. The Latin expression actus non facit reum nisi mens sit rea, loosely translated as an act does not render a man guilty of a crime unless his mind is equally guilty, expresses a foundational concept in criminal law. Crime are grouped under the following categories. First, crime against national security like treason and espionage. Second, crime against the fundamental laws of state like arbitrary detention and crime against religious worship. Third is the crime against public order like rebellion and sedition. And the fourth one is the crime against public interest like forgeries and the fraud. The fifth is the crime relating to prohibited drug. And the sixth is crime against public morals like gambling and betting. And the seventh one is the committed by public officer like bribery and malversation of public funds. And the eighth one is the crime against person like murder and homicide. And the ninth crime against the personal liberty and security like kidnapping and trespassing. And the 10th is the crime against property like robbery and theft. The 11th one is the crime against chastity like adultery and concubinage. And the 12th one is the crime against the civil status of person like simulation of birth and assumption of civil status. And the 13th one is the crime against honor like libel. And the last one is all about the criminal negligence. Against properties. Crime against property are crime of theft, where no force or threat of force is direct against an individual, includes crime in which property is destroyed, and crimes in which property is stolen or taken against the owner will. This consists of crimes such as robbery, extortion, motor vehicle theft, and many more. Against person. The term crime against the person referred to a broad array of criminal offenses, usually involving bodily harm, the threat of bodily harm, or action committed against the will of an individual. Those involving bodily harm include assault, battery, and domestic violence. Additionally, offenses such as harassment, kidnapping, and stalking also are considered as crime against the person.
For the basic elements of crimes, we have the actus reus, omissions to act, mens rea, concurrence, and causation. First, let us discuss about actus reus, or the physical act of the crime. It is a guilty act that is conscious and voluntary. Let me ask you this. Are we going to hold somebody criminally liable for an act that is not volitional and not voluntary? No, we're not. For example, a person who has a sleepwalking disorder commits a murder. Are they going to be found guilty of the crime? No. Next is the omissions to act. For its general rule, no duty to action on behalf of a stranger in peril. Additionally, there are exceptions by law. For example, you have a duty to automatically pay your taxes. If you don't, you could be held liable for tax evasion. There is also an exemption for contract or by contract. For example, a lifeguard in a pool is being paid to rescue and save people, but then the lifeguard was just sitting there flirting with a girl while someone was drowning. If the victim then drones, we can hold the lifeguard guilty of involuntary manslaughter for his failure to fulfill his contract. And there is also an exception by relationship. An example of this is a husband and wife have the duty to come to the aid of each other. The third element is the mens rea, or the mental intent to do the crime. It is about a guilty mind. The defendant knew that what he was doing was wrong. Where to find mens rea? Number 1, the specific intent crimes, where mentally he has to mean for that crime to occur. Example of this is theft crimes and intent to kill. Second one is the general intent crimes, where there is no specific intent needed to commit a crime. Example of this is rape and arson. And the third one is the strict liability crimes, that are crimes where the defendant's state of mind is immaterial. Example of this is speeding and parking in front of a fire hydrant. Next is the concurrence of the actus reus and mens rea. It's all about the defendant must both have a guilty act and a guilty mind at the time he committed the crime. And lastly, we have the causation. You only need to go to causation when there's a third party that's involved or an act of God.
Felony is a crime, typically one involving violence, regarded as more serious than a misdemeanor, and usually punishable by imprisonment for more than 1 year or by death. Example crimes of felonies are murder, robbery, and rape. Misdemeanor. A misdemeanor is a crime that is punishable by imprisonment for a year or less. Common misdemeanor includes petty theft, driving under the influence, and minor in possession of alcohol. Malum in se. It is a Latin phrase meaning wrong or evil in itself. The phrase is used to refer conduct assessed as sinful, inherently wrong by nature, or independent of regulations governing the conduct. Malum prohibitum, or simply wrong because prohibited. Crimes are criminal acts that are wrong because they are violate statute or law rather than being an action that harms or offends society. Examples are jaywalking, keep off the grass, no smoking, and no parking. Mala in se versus mala prohibita. Mala in se offenses are wrong by their very nature, while mala prohibita offenses are crimes that are prohibited by law but are not necessarily wrong in themselves. Infamous crimes. An infamous crime is a crime punishable by death in the state of penitentiary or imprisonment in a state of federal correctional facilities. Famous cases of infamous crimes are Alcatraz escape, Greenleaf's kidnapping, and etc.
Theories of criminal law. First, we have here the classical theory or the juristic. Man is essentially a moral creature with an absolute free will to choose between good and evil, and therefore, more stress is placed upon the result of the felonious act than upon the criminal himself. Did you know that the purpose of penalty is retribution? And also, man is regarded as a moral creature who understands right from wrong, so that when he commits a wrong, he must be prepared to accept the punishment therefore. Secondly, we have here the positivist theory. And here, the man is subdued occasionally by a strange and morbid phenomenon which conditions him to do wrong in spite of or contrary to his volition. Second fact is, did you know that the purpose of penalty is reformation? And also, there is a great respect for the human element because the offender is regarded as socially sick who needs treatment, not punishment. And also, crimes are regarded as a social phenomena which constrain a person to do wrong although not of his own volition. And last but not the least, the eclectic or mixed field. In here, this is combines both positivity and classical thinking. Crimes that are economic and social in nature should be dealt with in a positivity manner. Thus, the law is more compassionate. Heinous crimes should be dealt with in a classical manner, thus capital punishment.
Stages in the commission of the crime. First is the intention to commit the crime. Guilty mind to commit the crime. Intention to commit a crime is not punishable unless it is made known to others either by words. Preparations for the commission of the crime, arranging for the means and measures necessary for the commission of the crime. Preparation is not normally punishable, however, there are some exceptions. First is waging war against government. Second is preparations for counterfeiting coins and government stamps. Second is the attempt to commit the crime. Attempt is direct movement towards the commission of an offense after the preparation has been made. Attempt is those acts which cross the stage of being preparatory to the commission on an offense. And lastly is the commission of the crime. If the attempt to commit the offense is successful, then the crime is committed. For example, A fired at B with the evil motive to kill B, and B died immediately. This is the crime of murder. This stage is the commission of the crime.
Now, let's talk about the penalties. The penalties which may be imposed according to this code, and different classes are those included in the following. Principal penalties, which are the capital punishment, which is death. Afflicted penalties are reclusion perpetua, reclusion temporal, perpetual or temporary absolute disqualification, perpetual or temporal special disqualification, and prison major. While for correctional penalties, prison correctional, arresto mayor, suspension, and disciero. While for light penalties, arresto menor, public censure, and penalties common to the three preceding classes, which is fine and bond to keep the peace. And for the accessories penalties, perpetual or temporary absolute disqualification, perpetual or temporary special disqualification, suspension from public office, the right to vote and be voted for, the profession or calling, civil interdiction, indemnification or confiscation of instrument and proceed to the offenses, and lastly is the payment of cost. Here are the explanation. Reclusion perpetua is any person sentenced to any of the perpetual penalties shall be pardoned after undergoing the penalty for 30 years, unless such person by reason of his conduct or some other serious cause shall be considered by the chief executive as unworthy of pardon. Next is reclusion temporal. The penalty of reclusion temporal shall be from 12 years and 1 day to 20 years. While for the prison major and temporary disqualification, the duration of penalties of prison major and temporary disqualification shall be from 6 years and 1 day to 12 years, except when the penalty of disqualification is imposed as an accessory penalty, in which case it is the duration that be the principal penalty. And next is arresto mayor, which is the duration of penalty of arresto mayor shall be from 1 month and 1 day to 6 months. While arresto menor, the duration of penalty of arresto menor shall be from 1 day to 30 days, which is 1 month. So, lastly, bond to keep the peace. The bond to keep the peace shall be required to cover such a period of time as the court may determine.
Moving on to the participation of the offenders. It contains 3 major classes, which are principals, accomplice, and accessories. The purpose of this classification is to determine the proper penalty to be imposed on the accused. Article 17. Principals. The following are considered principals. Number 1. Those who take direct part in the execution of the act. Number 2. Those who have directly forced or induced others to commit it. Number 3. Those who cooperate in the commission of the offense by another act. Article 18. Accomplice. Accomplices are those persons who are not being included in Article 17, who cooperate in the execution of the offense by previous simultaneous acts. Article 19. Accessories. Accessories are those who are having knowledge of the commission of the crime and without being participated. Therein, it is either principals or accomplice. It takes part of subsequent to its commission and any of the following. Number 1. By profiting themselves or assisting the offender to profit by the effect of the crime. Number 2. By counseling or destroying the body of the crime or the effect or instruments therefore in order to prevent its discovery. Number 3. By harboring, counseling, and assisting the escape of the principal of the crime, provided the accessory acts with abuse of the public functions whenever the author of the crime is guilty of treason, murder, or attempted murder to take the life of chief executive, or it's known to be habitual, guilty, or some of other crimes.